The infamous long residence in the UK. Let's talk about that today. I have decided to do a video update on the 10 years long residence following recent case law. Continue watching for more information. Thank you for watching and being subscribed to Kareesha Law. I am Kareesha Turner, your human rights barrister. The story starts long before 2021. It is known law that migrants who have spent 10 years in the UK with continuous lawful residence can apply for indefinite leave to remain on the basis of their long residence, relying on paragraph 276B of the immigration rules and so on. Let me dispel a myth. It is 10 years lawful residence and not just living in the UK unlawfully for 10 years. Sometimes it may happen that the person has a gap in their 10 years residence. Prior to 2016, we had exceptional circumstances, and this was changed to paragraph 39E of the immigration rules, where the Home Office could discount short periods of overstaying during that 10 years. I won an appeal some time back where my client had stayed out of the UK for 8 months out of his 10 years lawful residence under paragraph 39E. So far so good. In 2019, the case of Ahmed came out and confused matters for migrants, lawyers and even the Home Office. It essentially said any period of overstaying cannot be used towards the 10 years. It was an interesting decision in that judges tried to interpret paragraph 276B, but it was a mess. It also cast doubt on the 10 years route. Some people despaired. It meant starting all over again to get those, or to clock the 10 years, 10 years for the lawful residence. We then had the other Ahmed case, which I will not bore you with, but let's talk briefly, for those of you who have heard of it, about the case of Hock. Hock essentially changed the position to introduce open-ended and closed-ended book cases, essentially saying periods of overstaying between, and that is the key word, between periods of lawful leave does not break continuity for the purposes of the 10 years lawful residence. But what about periods of overstaying that the person wants to rely on or to convert towards his 10 years? This is what the new case Asif talks about. Essentially, it says if the Home Office previously disregarded these periods of overstaying in between leaves, then it must follow that the migrant can use it towards his lawful residence. I will say Asif follows what Hock says and affirms the law about the 10 years long residence. I get a lot of questions on the 10 years long residence. It's not as simple as it looks, and a lawyer must consider your whole immigration history to see whether you're eligible for that route or not. But what it means is that you may, if you've had periods of overstaying in between your leave, you may not have to wait any longer. You may be able to make an application on that basis. It is worth having a chat with your lawyer to see if these periods of overstaying can be converted or used towards your 10 years lawful residence. You may qualify despite having overstayed, so get in touch with me and I will try to help if I can. Thank you for watching Kareesha Law.